Today I'm going to speak to you about fact-finding first, and then judgment writing. Now, in a way, it will also be a summary of some of the things we have already done and emphasizing some of the things that you've already done, both with myself and no doubt with the lecturers that have spoken before me. Now, everything you have done up to this point was meant to bring you to where we are today. You have to write a judgment. That's what it's all about. All you have done over the last 2 weeks was directed at what you must do now, which is to write a judgment. Now, see, I always say that judgment writing, which, by the way, is a subject I like to talk about. I really love talking about judgment writing. It's like parenting. Nobody ever teaches us how to be a parent. It is assumed that you have learned from what your father did, your mother did, from what your grandfather did, your grandmother did, and it's hoped that you will be a good parent. That's the problem of judgment writing. In parenting, just like judgment writing, is probably the most important thing that you do as a human being before you go 6 foot under the ground. Yet nobody teaches you how to do it. Judgment writing is like that. When you are a lawyer, when you are a judicial officer, your main responsibility is to write a judgment. But nobody teaches us how to do it. We go to university, spend years, including maybe doing PhDs, but nobody ever teaches us how to write a judgment. It's only very recently that the judgment writing is assuming some form of a science. And the Americans are excelling at that, and others are also catching up, where more and more guidance is being given to lawyers about the art of judgment writing. Now, the article which has already been distributed to you by Professor Raymond, I think it is Raymond, I think you got that one, isn't it? That's really a very good article. I like that article because it truly captures in a very nice way what the art is all about. There is another one by Justice Corbett. I'm not sure if Lorraine made that available. The article by Justice Corbett, if it has not been, we'll make it available to you. And that was written much earlier, more in the context of Southern Africa, and it's a very good one. As you know, Mr. Justice Corbett, late now, was a Chief Justice of South Africa, one of the best Chief Justices they have ever had. And I mean, if you read the Corbett judgment, you can see a master of the art. I mean, he really wrote some of the best judgments that I've ever come across as a lawyer and as a judge. So whatever he says, I think you should take very seriously. Now, having said that, I want to break the mold, therefore, through this program by talking to candidates who participate in this program about the art of judgment writing. Now, before you actually sit down and write a judgment, there are important preliminary steps before you can actually write a judgment. And the most important one is fact-finding. I mean, you can't just write the judgment, it's based on what you have found as the facts established in the case. So it's also a bit unrealistic to talk about the art of judgment writing without spending some time talking about the process of fact-finding. Now, I deal with this subject in this way. You should distinguish between motion proceedings and action proceedings when it comes to fact-finding, which is what I've moved to next. I'm sure by now you know that in motion proceedings, the evidence consists in the affidavits that have been compiled by the parties. Those are your facts. So it's slightly easier than the action process because you are really sitting with your affidavit. You don't have to worry about what did the witness say under cross-examination and things like that. Your affidavit is the evidence. And how do you approach the evidence in the form of the affidavits that you have before you? What is the fact-finding process? The applicant has said certain things in the founding affidavit, the respondent has answered, and the applicant has replied. That's the basis for your case. Now, the critical test in motion proceedings is what I'm sure you have now with which you are now familiar, and that is the Plascon-Evans test, isn't it? What is the Plascon-Evans test? Does someone want to volunteer? This you have to understand. If you don't understand that process, I tell you, say the other way around. The applicant's averments which are not disputed, you must accept. That's the first leg. The second leg, the respondent's version stands unless it is far-fetched, or it can be rejected simply on the papers. That is the test, the most basic test in motion proceedings. So the applicant has come to court. He has said certain things in his founding affidavit. Now, your task as a judge is to check what does the respondent say about what the applicant has said. That's what you want to say. Now, everything that the applicant, the respondent has not denied, that stands. But if the respondent in a serious way denies the averments of the applicant, the version of the respondent stands. That's the holy grail of motion proceedings. And unless you grasp that very, very basic concept, you will have great difficulty writing a judgment in motion proceedings. So the way you go about it is, I repeat, you look at the version of the applicant. Everything that the respondent has not denied, you must accept as correct, and that is a proven fact in the case. The aspects of the applicant's case which the respondent denies, unless it is far-fetched, unless it looks so untenable, you must accept. So you will see that in motion proceedings, the respondent has an advantage over the applicant to the extent that if he seriously denies anything that the applicant has said, the court must accept that version. And you have no choice. That's a matter of law. That's the legal principle that you must apply. It's not that you have a choice. Now, if the version of the respondent is so untenable, is so unreasonable, that it can, as we put it, rejected simply on the papers, then the version of the applicant stands. So that's very, very important to appreciate when it comes to writing the judgment in your motion proceedings. So in that regard, I have given you those cases in motion proceedings, the Plascon-Evans, the Stellenbosch Farmers Winery case, the Kumba case, and then in Namibia, the Mostert judgment, the Balsen judgment, the Selfco 51 judgment. And you'll see the Judge Straydom deals with it in a very simple way. And I like the way he deals with it. That's the number 7, the Permanent Secretary of Finance versus Selfco 51. He says, applicant has made certain allegation. Defendant files a very short affidavit. He does not even deal with the allegations of the applicant. Therefore, I must accept the version of the applicant. That's what he says. So that's the simplest, it is simplest. Now, if the respondent has come, and that's again the Monster judgment against Judge Stradom, read that judgment, very important. All of them that I have cited to you, read them please. In the Monster judgment, he says, the applicant has put up a certain version. The respondent has come and has denied each and every one of those allegations. He does it in a way that is serious, it is logical, and I cannot reject it. Therefore, the version of the respondent stands. That is the test in motion proceedings. So, unless you appreciate that holy grail in motion proceedings, your judgment on the facts in the motion proceeding will be flawed. And that's why it is so important that you must understand the process of reasoning. I'm sure you are referred to that. If the disputes arise on the facts, your duty as a judge is to see the way in which somebody raises disputes on the facts. Does it really do it in a way that is genuine and serious, or is it really a very unserious way in which the allegations of the applicant are being denied? So the room hire test is that only those issues on which the respondent is able to make out a case, only on those issues on which the respondent raises serious and genuine dispute of facts, can you be satisfied that the applicant has not met the test. So not every denial must be taken seriously. It must be a denial that really damages the case of the applicant. If the denial does not damage the case of the applicant's version will stand. So that's as far as fact-finding process in motion proceedings is concerned. And I'm sure it has also been mentioned to you that the parties may, in appropriate cases, request the court, in terms of the appropriate rule of the court, to take matters or certain disputes to be referred to oral evidence. Have you dealt with that? In that case, you are going to hear oral evidence. You are going to put aside the affidavits. The affidavits will form the basis for the pleadings, and the court will hear oral evidence on which the parties will be cross-examined in order to determine which version of the parties is to be accepted. And that again demonstrates to you the importance of the statement that motion proceedings are not intended for the resolution of disputed facts. So that if there are genuine disputes of fact, and the court takes the view that it cannot resolve the issue without hearing oral evidence, it must be referred to oral evidence so that the parties can be cross-examined. So, by way of summary, in motion proceedings, the holy grail of motion proceedings, as I put it, the affidavits are both the pleadings and the evidence. The party must make out its case in the affidavits. And if he or she has not made out, if the applicant has not made out his case in his finding papers, he cannot come and remedy the position in the replying papers. Only 3 set of papers are allowed. If 4th set of papers are going to be allowed, that's only with the leave of the court. Very important principle of our proceedings, in motion proceedings. The version of the applicant that is not disputed stands, unless the version of the respondent is to be accepted, or the version of the respondent is to be accepted unless it is so far-fetched that it can be rejected on the papers. And this is what was said in the Balsen versus Nederlof judgment, which I also gave to you, and I quote it. Should disputes of fact arise on the papers, the court may still grant a final order if the facts deposed to by the applicant and admitted by the respondent, and the facts alleged by the respondent justify such an order. Even if the facts are not formally admitted, but it is clear that they cannot be denied, the court must regard them as admitted. In certain circumstances, denial of a fact may not be such as to raise a real dispute, genuine or bona fide dispute of fact. Should a genuine dispute of fact exist on the papers, and it was not referred to oral evidence, the court must accept the version of the respondent unless it is so far-fetched that it can be rejected simply on the papers. I want to move on to actions. You want to ask questions on this? Do you understand the process of reasoning in motion proceedings? The facts admitted by the respondent must be accepted. They stand, so the applicant's version stands unless it is denied, and the respondent's version must be accepted unless it is far-fetched or it is so untenable that it can be rejected on the papers. That's the process of reasoning. Then the respondent has raised a genuine dispute of fact. So the applicant has a problem. The first problem is that he or she should not have proceeded by way of motion, because they now have to be cross-examined to determine whose version should be believed. So in those circumstances, and read again carefully the Monster judgment, who bears the risk of non-persuasion here? It's the applicant, because he's the dominant litigant party. So in circumstances where he should have anticipated a genuine dispute on the facts, he should not have proceeded by way of motion. But if he did, regardless anyway, and he still does not ask the court to refer the matter to oral evidence, you'll have to dismiss the application because the applicant has not met the test. Now, there are certain circumstances in which it is a requirement of the law that you must go by way of motion. Say the review application. So in those circumstances, you can really not fault the applicant for having gone by way of notice of motion. But the principle still remains. If you anticipate disputes of fact, or if, let me put it this way, if genuine disputes of fact have arisen, which the court is unable to resolve without referral to oral evidence, and the applicant fails to ask the court to refer them to oral evidence, you will have to dismiss the application. It is preferable that the parties request the court, but I see no harm in the court pointing out to the parties that I don't think I will be able to resolve this dispute without hearing oral evidence, without the parties being subjected to cross-examination. So if there is no other question, no further issue on motion proceedings, if you understand the holy grail, as I call it, of motion proceedings, I am moving on to action. Now, action proceedings is now where the people have filed their particulars of claim, combined summons with particulars of claim. The defendant has filed a defense by way of a plea. There was a replication, pleadings have closed, and people have come by way of witness statements to testify, and it is now your duty to decide which version of the parties you must accept. Did Advocate Van der Westhuizen deal with the test in action proceedings? You see, you must always remember, you are guided, as I mentioned to you, by two things. The first one is the burden of proof. When you come to decide which version to accept, in whose favor you must decide or not, always go back to who bears the onus of proof. That must be your starting point always. And if you are clear about who bears the burden of proof, you are guided next by the pleadings of the parties. The issues should be defined by the pleadings that the parties have filed in court. Nothing else. As I mentioned to you the first day, you don't go on a frolic of your own. What you are going to decide in the case will be determined by the pleadings and how the issues have been defined by the pleadings. And it is your duty as a court to hold the parties to their pleadings. And in terms of our rules of court now, the pretrial order tells you what are going to be the issues that are going to be adjudicated. Because the pretrial order will set out the issues of law and the issues of fact that will be determined at the trial. And the evidence to be led and the manner in which you as a court are going to determine the matter should be guided by that. So the pleadings are your guiding light. But that's easier said than done. I'm going to give you some hints about how you can go about resolving which version to accept and which one not to. And again, remember what I mentioned to you yesterday, the Govan versus Skidmore test. Is the version, which version is the plaintiff's version more probable than not? The party who bears the honors, you must be satisfied that his or her version is more probable than not. That's the Govan versus Skidmore test. In other words, you are deciding the case on probabilities, preponderance of probabilities, as we call it. If you are satisfied that the plaintiff's version is more probable than not, if the plaintiff's version is more probable than that of the defendant, you must decide in favor of the plaintiff. But if the defendant has been sufficiently meticulous in puncturing the case of the plaintiff to create holes in his case, that the plaintiff's version tends to be less probable than that of the defendant, you must find for the defendant. So again, you are going back to the standard of proof. Guided by the burden of proof, you go back again to the standard of proof, which is a preponderance of probabilities. And I cited to you the crude example I gave you yesterday of how you can go about determining probabilities. A person who seeks to enforce a loan debt against another of a substantial sum of money. I go back to the example I gave you yesterday. What are the probabilities? And probabilities in the crudest form really is how does human nature work? How does human nature work? That somebody who advances a huge sum of money to another for a considerable period of time does not enforce that debt. But only in circumstances where the other person makes a claim against him, seeks to enforce that claim against him. What are the probabilities that two people who are strangers, completely strangers to each other, will lend each other money, and the other one who has advanced the money would not enforce a debt of $1 million for a period of, say, 5 years? It's improbable. But it's possible. But is it probable? So you must logically work through in your minds how to deal with probabilities when you have two versions that you are dealing with. Of course, it does. You see, the chances that I will lend money to my brother or my son are very good because there is that family relationship. So the chances that I will give a donation or a gift to a member of my family are very good. But the chances that I'll give a free loan, or I mean a free gift to a stranger are not very good. Unless, I mean, you are a big philanthropist who has billions of dollars walking around and distributing money amongst people. So, so that's one way of looking at probabilities. So if I come and say, I lent my brother $1,000 and he agreed to pay me back, I want my money back. He says, no, look, man, he's my brother. I was in trouble. He gave me the money to help me out with a problem. The chances that that could have been a gift are greater than if the two of us were strangers. To be very specific to what you have asked. Oh, yes. Look, the example I gave you, the chances that I can give a gift of $1,000 to my brother are very good, without the expectation of payment back. But the chances that I'll give him $50,000 without being paid back are very slim. It doesn't mean it's not possible, but they are slim. So the chances that I'll try and help him out with a $1,000 are very good. But if I say I lent him $20,000, $50,000, and I expected to be paid back, the chances that that could have been a loan are greater than if it was $1,000. So now, when you have two versions of protagonists, the plaintiff and the defendant, and as we call them in the business, two irreconcilable versions of the parties, what is the test that you apply? Now that test is set out in the judgments that I gave you under B in action proceedings. The South African one, the first one is the Stellenvale, and the second one is EU versus Minister of Education. Simply put, what it says is that you have to make credibility findings of the various witnesses. You must deal with the reliability of the versions of the parties, and most importantly, you must deal with the probabilities. Very, very important test in action proceedings, and you must get familiar with that. So if you have two irreconcilable versions, you must try and determine which of the two versions is more credible, which of the two versions is more reliable, and ultimately the probabilities in the case. As part of that process, you are guided by the demeanor of the parties. The same thing that we do in criminal proceedings. As we famously put in criminal proceedings, I saw the witnesses, I saw the accused in the dock. He was shaking, he was nervous, he looked untrustworthy, and therefore, in the circumstances, I cannot believe his story. I would rather believe the story of the other witness. But I must warn you about demeanor. Demeanor is a very, very unsafe guide to deciding a case. There are certain circumstances in which clearly it can help you and assist you to decide a case. But as we all know as judicial officers, those of us who sit and preside in cases, your most honest witness can on that day turn out to be the poorest witness because the circumstances are strange of the court. Maybe it's the first time the person appears in court, he's nervous, he's in a strange environment, So people could be nervous. People could find themselves in a position where they cannot even answer a question. Not because they are lying, but because they are afraid of the environment in which they are. So be very, very careful about basing your conclusions entirely on demeanor and what you see in the witness box. As I always say, probabilities are always your best yardstick for determining a case. And how do you go about deciding the probabilities? I'll give you a few hints. The first one is, to what extent does a party keep to his pleadings? You will find that somebody will say on his or her pleadings, he will give a particular version. We met on the 20th of November in Okahanja. That's where we entered into the contract. That's his pleadings. Under cross-examination in the witness box, he says, we met in Windhoek on the 21st of December. That's where we entered into the contract. Now, the version given in evidence contradicts the version given in pleadings. That already gives you a guide that you cannot accept the version of that one party. So always be guided by the pleadings. How consistent is a party's version under oath with the version given in the pleadings? That's one way of looking at it. Another one is previous inconsistent statements. To what extent has this person's version been consistent throughout? And that normally comes out in cross-examination. Cross-examination properly deployed can be the most effective tool to determine the truth or untruth in a person's version. So previous inconsistencies between oral evidence and pleadings should help you to see whether you are prepared to accept that party's versions. Most importantly, another one is a failure to cross-examine. I mentioned to you the other day about the importance of cross-examination. Cross-examination is both a right and an obligation. And the authorities that I have provided you, I've now sent them through to Lorraine already. The rugby case of South Africa, that's Judge, the leading judgment in the case puts it so nicely. And I want you to read it very carefully and to understand it. If you want to come and say that the version of the other side must not be accepted, it is your duty to challenge that version. Now, if you fail to challenge the version of the one party, the opponent, that version will be taken as the truth. So if somebody comes in his evidence in chief and puts a particular version of events which contradicts what you think is the correct version, and you fail to contradict that version under cross-examination, either to say you are lying, it could not have been the case because this and this is the truth. You cannot expect the court to come and accept your version as opposed to the version of the other side. So a failure to cross-examine an opponent on a very crucial issue is one guide you must use. And this applies both in criminal and civil context in determining where the probabilities lie in a case. Another one is this. If I say that on the day that I advanced the loan to you, I was together with Mr. Simpson, and he witnessed me giving you the loan. Now you are potentially my witness. But when the trial comes, I fail to call him as a witness. What does that suggest to you? Now, as between me and you, it's he said, she said. But if there is another person who can corroborate my story, and I fail to call that person, The court can draw an unfavorable inference from my failure to call a person who is potentially available to come and corroborate my version. I want you to read the case of Brandt versus Minister of Justice and another. Brandt versus Minister of Justice and another. 1959, Volume 4, SA 712, brackets A, meaning Appellate Division, at 715 to 716. A failure to call a witness creates the risk of the owners being decisive. Very important. So if there is a potential witness who can corroborate my version, and unless I can demonstrate that there is a reason why that witness is not available, if Mr. Simpson has in the meantime traveled to China, I cannot afford to bring him back. I have a good reason for why I cannot call him. But if he is available and I fail to call him, in cross-examination it emerges, Mr. Damaseb, you say Mr. Simpson was present? Yes. When last did you speak to him? Last month. Does he live in Windhoek? Yes. Why didn't you call him to come and testify to corroborate your story? Well, I just forgot. The court can draw an inference against me. Another technique you can use, and there are certain presumptions that we use in specific cases, is say in accident cases, there is an important rule. We call it the rule in Galante versus Dixon. Galante versus Dixon. Galante, Galante versus Dixon, 1950. Volume 2, SA 460, brackets A, capital A, that is Appellate Division, at 465, paragraph 20. Now, there is a special rule in accident cases which says, and I'll first read it to you and explain it to you. Where the defendant was himself the driver of the vehicle, the driving of which the plaintiff alleges was negligent and caused the accident, the court is entitled, in the absence of evidence from the defendant, to select out of two alternatives explanations of the cause of the accident, which are more or less equally open on the evidence, that one which favors the plaintiff as opposed to the defendant. Important rule in accident cases, so it only applies in this circumstance. Two people are involved in a motor vehicle accident. The plaintiff was the driver, the defendant was the driver. The plaintiff comes to testify. The defendant refuses to testify. And the plaintiff gives two alternatives of how the accident could have occurred. He says, I think he was driving too fast in the circumstances. Or I think he failed to apply his brakes when he should have applied his brakes. Those are the alternatives that the plaintiff gives. The defendant doesn't testify. Now, what the rule in Galante tells you is that if the plaintiff gives a version of events, there are two alternatives to it. Each one of these alternatives is plausible on those facts. You must accept the version of the plaintiff. So it's a very specific rule, and a specialized rule which applies only in respect of accident cases. So when you are dealing with an accident case, remember Galante and see if the defendant does not testify. If the defendant doesn't testify, I want you to go back to Galante and see what the plaintiff is plausible in the circumstances. Another tool you can use is the what I mentioned to you in the exchange I had with Nelly. There is a law against, not a law, there is a presumption against donations. You see, at common law, the common law presumes that we do not freely give things around. It doesn't say you cannot. So if I say that I gave a loan to you, the inference is that I intended to be paid back. Or let me put it this way. If I gave you money, a substantial amount of money, the inference is that it is a loan because there is a presumption against donations. So if a defendant says the $50,000 that he gave me on the 20th of November was a gift, he has a big sell, I must tell you. Because human nature assumes that people do not freely give things unless there is a special relationship or the circumstances of the case justify that I wanted to be a free, I wanted to gift a person in, without being paid back. Therefore, if someone says that I have given him a gift, he has a burden to allege it and to prove it. So if I claim return of monies given to you as a loan, and you say it was a gift, it is your duty to allege that it was a gift, and you must present evidence to show that I intended it to be a gift. The other one is this. If somebody makes a serious allegation against somebody, we expect them to produce strong evidence to sustain a serious allegation. So if you allege fraud against someone, and there is a judgment of our courts in Courtney Clark and Basingwaite judgment it is, where the principle is enunciated, that allegations of fraud are treated very seriously by the court. So if you make an allegation of fraud against somebody, the court expects you to produce strong evidence to sustain that allegation. And remember, all these things that I'm saying to you is to help you now to decide how you are going to decide the case. It's fact-finding process. You are writing your judgment. So I'm sitting here with two versions where somebody has alleged and made a serious allegation of fraud against another person. I expect to see in the evidence that they have laid before me very, very strong evidence to sustain that allegation. That's what it's all about. So fraud must not only be alleged, as we say in the business, it must be established by strong evidence. And again, go back to some of the things that I mentioned yesterday about whether there was inadmissible hearsay evidence, whether there was opinion evidence which was offered by a party which you cannot accept because the person was not an expert, and so on. So I can go on we'll give you a long list of some of the techniques that you can use, but I've just highlighted some of them that can be of use to you in determining which of the versions to accept and in determining where the probabilities lie in a case. Okay, so please, I want you to read Stellenvale. I want you to read Minister of Education to get the test that you apply and think about some of these techniques that I have mentioned to you today. Anything by way of question or comment before I move on to judgment writing? So here you are, you have established what the facts are. You are satisfied. I'm now accepting the version of so-and-so as opposed to that one of Y. And now I'm going to now record my thoughts on paper. That's your judgment. Now, I can do no better than refer you back again to Professor Raymond's article, which is very, very instructive. And I've also provided to Lorraine a template, which I think you got. And I will be brief here. I just want to highlight a few things. You see, when you are writing a judgment, you should always remember you have an audience. Your most important audience are the two parties before you. And always remember this. Especially the party who loses wants to know why they have lost. Always remember that. So you want to communicate with both parties, but especially to the losing party. Not so much that he should agree with what your reasoning is, but at least to understand why they have lost. A worst judgment is one which just says, I have listened to the evidence, I don't agree with what the defendant says, or I don't agree with what the plaintiff says, therefore I find for the plaintiff or the defendant. People are entitled to know why they have lost, especially when they have lost, they want to know why they have lost, and that is the reason for your decision. Now, I always say that you should, in your professional life, be inspired by somebody. You should be inspired by a style of someone whose judgments you read. I've already mentioned to you how useful I find judgments written by the late Justice Corbett. And I always try, when I write a judgment, to perfect his art. I want to equal him or write better than he does, which is very difficult because, as I said to you, he was a master of the art. Don't ape somebody's style. Develop your own style. But try to draw inspiration from the way somebody writes. And reading the judgments of our courts, both in the High Court or the Supreme Court, say, I like the style of that particular judge, either because of their simplicity or their manner in which they write, and try to follow that pattern of the particular person. But, you know, as I say, don't ape a person, develop your own personal style. One thing you should never do is, when you write a judgment, to try to be bombastic, to try and sound very learned, you know. I always say prose and poetic language comes with time. We don't all have it. It comes with time. It's developed over a long period of time and practice. But at the beginning, you know, and I mean, most of you are sitting here have already written judgments. But especially when you start with a very simple style of judgment writing. And over time, excel and perfect your art. But start with a simple approach. The most important thing, and that's what Professor Ramon tells you, there must be a logical sequence in your judgment. And if you look at the judgments we write these days, there is normally an introduction, we provide headings, so that you move from one subject to another. And as Professor Ramon says, always provide a context. You see, in the first 2-3 paragraphs, I want to know what the case is about. I don't want to wait until page 6 or 7 to understand what this case is all about. The first 2-3 paragraphs, I want to know what the case is about that I'm reading. And I can tell you personally, I devote a great deal of time to this. Even if it takes me 1 or 2 hours to just work out, to tell the reader what this case is all about, I try to do that and put it in the first 2 paragraphs of the judgment. And the rest is easy once you know what the case is all about. Try always to be brief. Avoid long sentences. And as I say, context before detail. Once we have established the context, begin now to move over to the detail. And we also want to know, how did the people come before you? What is it an appeal? Is it a case involving a contract? Is it a delict? You know, that sort of thing is what you want to do already at the beginning. You see, after you have read your affidavits, if it is a motion, or after you have done your reading of the record, or you have finished hearing the case, and believe me, if you don't put aside your papers and sit with only a blank piece of paper and a pen and write 5 pages about that case, you don't understand it. You should be able, after you have finished the case, to put all your papers aside. Take your exam pad, your pen, and start writing, even if it is just 3 or 4 pages. If you don't do that, you don't understand your case. Because what do you do if you don't do that? You go and take your papers and you start paraphrasing. And that's the worst judgment ever. So try always to develop a skill to summarize things. And you can only properly summarize if you understand the case. And you only understand the case if you know what the pleadings were and what the evidence is in the case. And those tend to be the shortest and the most succinct and powerful judgments, which are prepared on that basis, where a judge or judicial officer puts aside the papers and starts summarizing the case. Sometimes begin to speak to yourself. You know, develop the, people may think you are not completely right in your mind, but you find it very useful if you walk in the morning, if you take long walks in the morning. Talk to yourself about your case, and you will realize the magic that does for you. Because when you come back from your long walk and you just sit down and write, ideas flow. But once you go now and sit and your notebook and start summarizing, that's the worst possible judgment that you can write. So try to learn the art to summarize what you have read and be very succinct about things. No, but let me make this point. You see, one habit you must develop, and I find it very useful, is that immediately, every day after you have heard the evidence, try and go and sit by yourself and think about what happened in court. And think about the witnesses. You actually see them. As you sit, you can visualize their faces and you think about what is said. And make notes about what you found remarkable or particularly interesting about the evidence of that witness. Either the consistency or the contradictions in that witness's testimony. And make notes about it. because that's really your summary of what you are going to say about the version as you'll accept it or not accept it. It helps you a great deal if you do that, because even at the end of the day, it makes your task easier in terms of judgment writing. And particularly, it helps you because you don't want to go back to the record to regurgitate what the witness has said. If you are able to summarize briefly what you recollect from what the witness has said. And the other hint I want to give you is that before you start writing, on that piece of paper that I was telling you about, before you even write it 3 or 4 pages, create a roadmap. Create a roadmap for your judgment. You have the various headings. I want to have a heading, introduction. I want to have a heading on where I will analyze the law. I want to have a heading where I will analyze the evidence, and where I will decide what I normally call the disposal heading, where I decide which way the case is going to go. So develop a roadmap for yourself, because that disciplines you in terms of what you will write and what you will not write. And the good thing about the roadmap and developing the headings under it is that you can write each one of those things separately. You can write each one of them separately. So if you have a heading, for example, on disposal, that is where you are going to decide whether you, which way you are going to decide the case. And I can tell you, in my case, that is the one that I write first. I write down, first of all, in my judgment, how I'm deciding the case. And then I work backwards. I will make a clear summary of the, if I'm interpreting a statute, I will say, I therefore come to the conclusion that section such and such of the Companies Act means this and this and this and this and those. I'll make those notes, and then I work my way backwards. So the beauty about having them in those compartments is that, as Professor Ramon suggests, you can actually write each one of them separately. You can write the section on the analysis of the evidence separately, the introduction you can write separately. So once I have done my disposal section, I'll usually go back to the introduction. Introduction where I try to explain what the case is about, because that helps me to appreciate whether I actually understand the case or not. So my style, develop your own, but if you clearly compartmentalize them about what you are going to say and develop a roadmap, it makes your task very easy. And the template is only a suggestion, what I have given you, please. But it's very helpful, and that is the style that we use at the moment, especially in the Supreme Court. Where you have a small introduction, you have headings, you can go to defining the issue, what the parties' submissions are, and so on. You know, you clearly compartmentalize them. You see, the order is your most important part of a judgment, yet is one of the subjects that are given the least attention. And again, as I said to you, together with my disposal section, I'll also do my order. In the premises, I decide the plea must, the claim must fail, costs are ordered against the plaintiff, and so on. That order is clear, because that also helps you to work backwards and be clear about what you are saying in the body of the judgment. You see, the one thing you must never do, and I tell you this from experience and based on experiences I have had with some colleagues in the judiciary who have had difficulty writing judgments, is that don't think that you can start writing and find the answer at the end of the day. Some people will, and this is true, literally. One colleague put it to me. I said, but why do you take so long to ride? And so, no, what I do is I start riding, and maybe in the process I'll decide, find the answer. It's a wrong approach to judgment riding. Right or wrong? You see, our duty is to decide cases. That's our principal duty. Based on the law as we understand it. You can never decide a case based on the law as I understand it. You only decide it based on the way you understand it and the way you understand the evidence. And at the end of the day, you have a view about what the law is. You have a view about what the evidence is. You must make up your mind. Right or wrong. There are other people who are going to decide whether you are wrong. That's how our system works. And especially at first instance, our duty as judges of the High Court, our duty as magistrates, is to decide cases and to move on. That's our duty. If we get it wrong, there are three people who sit somewhere and say, look, you got it wrong here. But at first instance, our duty is to decide. So please don't make the mistake to start writing and hope at the end of the day the answer will just show up. It never happens. Decide right or wrong and start writing your judgment. So I've spoken about order, the order, how you frame the order. You should spend a great deal of time thinking about your order in a civil case. I tell you, it is so important. The order must be self-explanatory. It must be self-contained, self-sufficient. It must stand by itself. It must not be understood by reference to something you have said in the judgment. It must stand by itself. It must not create doubts in the minds of the parties about what you have said. It must be very clear. The plaintiff has succeeded. I'm granting damages in the amount of 50,000. Very clear as that. The defense is dismissed. The plaintiff's case succeeds, and I grant judgment for the plaintiff as follows. Spell it out. Don't leave anything to doubt. And always deal with costs. Always deal with costs. How you are going to apportion the cost in the matter. Judge Parker has spoken to you about costs. Remember the principles, he spoke to you about that. So your order must be complete and stand by itself. I must not go to a judgment to understand what the order is, because this higher court may decide that your reasoning was wrong, but still agree with the order anyway. So the order must stand by itself. And the parties must not be left in doubt about what you have decided. And it must relate to the issues that was placed before you by the parties. In the particulars of claim, the plaintiff would have told you what is the relief that he seeks. The defendant would have told you what is the relief that he seeks in opposition to the plaintiff's claim. Notice of motion, the notice of motion is the one that guides you about how your order must read. And one final thing I want to mention about the order, if you sit in the High Court, you may hear an appeal now from the Magistrates Court. You must remember that an order you make in an appeal case is different from an order you make in a case at first instance. Because especially now, if you say reverse the decision of a lower court, the order you are making is the order the lower court should have made. That's the order you make. So I want you to take time to look at judgments that emanate from the Supreme Court or those from the High Court relating to judgments from the Magistrates Court. So if you are reversing a lower court, you will say the appeal succeeds. And therefore I make the following order. And usually we put it under quotation marks because that is the order the lower court should have made. So if the High Court should have dismissed the case of the plaintiff, but it allowed the case of the plaintiff, what it will say is that the appeal succeeds, and I make the following order. The claim is dismissed, and you make the order of cost that the High Court should have made, but you also make an order relating to cost that the Supreme Court makes in relation to the appeal before it. So remember, there is always a difference between when you are dealing with an order, where you are dealing with making an order involving a case at first instance and a case involving an appeal, where you are reversing and making an order that the lower court should have made. That comes with practice, but look at it, the more you read the judgments coming from appeal courts, you'll be able to work that out. So I want you to take seriously, read as often as you can the article by Professor Raymond. Acquaint yourself with the approach that he suggests there. Develop your own style about judgment writing. And once you have developed your own style, try to perfect it as you advance in your career. Try and always learn from how others do it. Try to be as clear in your exposition, both of fact and the law, as you can. Avoid being bombastic. Be as simple as possible. Remember, you have an audience. Try to address your audiences. And that's the parties before you. You are also addressing the broader legal community who are going to read your judgments. And you are going to write judgments in the High Court. They are binding on the magistrates' court, so it forms precedent. You know, always remember that you are bound by decisions of a court above you, and try to follow precedent as faithfully as you can. You should follow judgments of both the High Court and the Supreme Court unless you are able to distinguish them on the facts or on the law. That's the principle of stare decisis. We are bound by previous decisions. We don't want the chaotic state of the law where each judge decides as they please. You can only depart from a previous judgment of the same court, even if you disagree with it, if you are satisfied that it is clearly wrong. That's the test. You can't say, in the case decided last week, Judge Angula decided that this is the proper way to decide this issue when it comes to asset forfeiture. I decided to follow this route. You can't do that. You must follow a previous decision, even of a judge of the same court, unless you are satisfied that it's clearly wrong. When it comes to the Supreme Court, you are bound. Even if you are convinced deep down in your heart that it's wrong, you must follow it unless you are able to distinguish it on the facts or the law. So those are my hints to you on judgment writing and fact finding. Any questions? Will it improve your judgment writing from now on? No questions. Everything is clear. So we are going to see masterpieces in the form of judgments coming from you. Sorry? It's going to be a work in progress. Well put, yes? Will you write a judgment? Probably, yeah. Short judgment, yeah. Yes. Or maybe even 15 minutes, you know, I don't know. Should I switch off this? Yeah, no, thank you. Important point, we are trying to lay the foundation for you, you know. Use this as a basis for your further professional development. If you show promise, those who show promise, I mean, this is not the end of it. Those who show promise may be invited to act. If you are invited to act, you will be afforded the opportunity to see things in practice. We normally provide mentoring, which is where this comes in. But you see, you can't go to what you call the practical unless you have the theory. And it's unrealistic in a program of this nature. I will have to run a period of 6 months to do those things. It's not realistic. But it's true, to the extent that we are able to, we should do that. In fact, it's only costs that really hamper us in this. What's expensive to do something like this? The idea we have with this program is to have what we call the basic and the advanced. The advanced is for those who do well in the program to be brought back to do, those who do well in the basic to be brought back for the advanced, where we now deal with further detailed subjects of substantive law and do more the practical side of things, you know, attachment to seat of judges. But the problem is money always. You know. But we'll improve as we go on. And you know, thanks. And you see what I said to you at the beginning, I repeat now. You should continue to read. Make it a habit to go on the website and read the judgments of the High Court on particular aspects of the rules. Keep yourself, what I always tell people, your own self-study file where you make notes about recent judgments, you annotate them, and that's the only way you continue developing, I tell you. Let this not be the end. After these, well, in any event, they have not asked me to come and act there, so I forget everything. Don't do that. Develop yourself. Develop yourself. Keep a copy of the rules. Read them always. You know, if a judgment has come out dealing with that particular rule, make an annotation there. You know, that's how we develop ourselves. I do it to this day. I mean, every day I read something new. I make notes. I keep them. I use them. You know, that's how we develop. The process never ends. Learning never ends. You know, we all learn something new every day, I can tell you. Every day we learn something new. But the important thing is to develop that skill to, say, take a set of facts and use the techniques that we taught you now to write a judgment. I mean, 60% of the judgments I would write relate to areas of the law I've never even studied at university. But the idea is that you use the skills that you have developed. I mean, I was never trained in Roman Dutch law. I was trained in English common law. I had to convert to Roman Dutch law. But the skills that you develop there, as what you can use, I mean, this is how will I go about finding facts, how will I go about analyzing the law and apply my skills. That's how you develop, you know. And you see, thanks very much, I'll convey. Your group was in a better position than the first one was, because the first one, it was over a period of, I can't remember how long, the lawyers, apart from me coming at the end to speak about the bit of judgment writing, it was just rules, and the people left. But this time I decided to bring in judges so that you can speak, they can speak to you about practical side of the. So we are improving on the program as we go on, because the judge will not come in and just talk about rules. He talk to you about how they do the things in the practical. I mean, what I've said to you today has nothing to do with rules. This is real life. This is how we decide things, you know. No, good luck. And so you won't see me again. You'll see the registrar and Mr. Netorlov briefly today, just to complete the picture. I want you to see how each justice works. It's non-examinable. I want you to see how mediation works. There won't also be a question in the examination. But I just want you to know how it works, with the complete picture of how the High Court works. And then the arrangement is that on the 4th and the 5th of December, exams will be written. Supreme Court, Oshakati, Lorraine is putting that in place. The time has been given. All you do is to present yourself on that day, the Supreme Court, if you are in Windhoek, Oshakati, if you are there. And then, as I said, you'll be allowed to use the rules of the court, the High Court Act, Labour Act, and the practice direction. Did they touch a lot on the practice directions? Yeah, bring them. As I said, I have yet to see all the questions that have been posed. I do not know to what extent they will be relevant. But we are also in communication with you through email, isn't it? So we will let you know if anything changes from what I have said. But otherwise, good luck. As I said, we are not trying to catch anyone out. We just want to see whether you understand what you will not be asked to analyze the rule, or what does rule so-and-so say. I mean, it's just to try and see how you can apply the knowledge that you gained over this couple of days. But I hope you enjoyed it, and good luck. All the best in your professional endeavors. So now it's break until lunch.